My name is Annika Nilsson, and I'm doing a postdoc project called Legal Approaches to Controlling Emissions of Nutrients in the Baltic Sea region. And it consists of country studies and a comparative study. And also the main applicant for these projects is Jonas Ebbesson, the professor at the Faculty of Law, while I am then the main active researcher here. And we have then involved also legal scientific researchers in 3 different Baltic countries to do country reports for us to base this study on. Because I am looking to analyze and compare national laws regulating eutrophication or nutrient emissions with the view of doing something about eutrophication. My project is a 2-year project from 2012 to 2013. The idea is to report then during 2014 in articles. And I am then comparing national regulation of on nutrient emissions then. Because law has really, the law as a policy instrument, it has the role to have objectives and standards which are often set by politicians and based in natural scientific information, data, and your research that we have heard you present here. But then in the legal system, it's kind of translated through national responsibilities and knowledge to enforceable duties and responsibilities for human actors. Because regulation as a policy instrument has the special role that it's authoritative in that manner that we can command and control through national institutions. So that's really what why it's important to also look at the different instruments and how do they fulfill this role as a policy instrument and as a management instrument. So I am looking at legal potential and challenges, because there are a lot of challenges of realizing ecological objectives, and to try to study the potential of ecosystems approach. Well, the points of departure is the sustainable management of Baltic Sea ecosystems and resources, of course. This means then, I depart from the idea that then governance must be based on an understanding of interdependent ecological and social systems. And then that legal systems must be sensitive and adapted to ecological functions and changes. And with these points of departure, I will go into the study, or I have gone into the study national legal systems and compare them and try to see, is there any potential here for ecosystems approach in practice when regulating? For this, to make this practical, in the country studies, I formulated some criteria. I do acknowledge that the ones that Britta mentioned are more full, but to make it manageable, and that is to have regulation based on ecological quality and standards, to have adaptiveness and responsiveness, but also the stakeholder involvement. So with these criteria then, we have gone into studies of national regulation. And the countries we've studied is Sweden, Denmark, Estonia, and Poland. And we have studied the regulatory areas of water pollution from sewerage and agriculture. And I have set up some common questions like a template for these country studies. So it's kind of a methodological experiment also to try to see how can I kind of get these researchers together, and so I can make an analysis from their reports, which are largely very descriptive. This is the data. It has some challenges because I don't have control over reports more than with the template. But then the comparative legal study then widens then my analysis of these potential and challenges and how the different regulatory systems look. And the idea, of course, in the back of my mind is to try to find new instruments, new perspectives, a deeper understanding of regulation as a policy instrument. And these are some preliminary results, I would say. They are not published yet, from the country reports and my comparative observations. The aims and objectives are based on ecological policy and standards in the regulation. And we have water management systems, of course, that are based in EU law. These are based in ecological status, have norms and measures, systematic coordination, flexibility, connection to ecosystem needs, and stakeholder participation in the management cycle. However, often we can see that, at least in Sweden, that management authorities are not operative. They are not regulating themselves. So in the operative decision making, the regulation, here stakeholder participation and the connection to ecological quality is in practice quite weak. So the tools and competences for regulation of the individual actors are very much business as usual, same instruments as before. And adaptiveness and responsiveness is rather slow. So what we need really is institutional structures and procedures for linking the management strategies with the operative regulatory measures, with the law, the command and control. And perhaps also to educate operative regulators. So, further questions which I am working on now when trying to analyze these materials is, what does ecosystems approach entail in the context of regulation? Aims, substantive norms, procedural norms, and what legal structures are necessary to support the functional ecosystems management system from a legal perspective? What is the role of law in this system? Because even though we have the command and control, this is not the most important instruments. The supporting communicative instruments are often quite more effective. But what is the role of law in this coordination? And also the challenges and the potential for regulatory means of ecosystems management. And this I'm planning to do some more theoretical work in. What does ecosystems management really mean for us lawyers? And by that, these are my ideas. Thank you.